Good afternoon, everyone. Welcome to the BCSTH Legal Toolkit webinar, the general information about legal issues and court matters in British Columbia. I am calling from or speaking to you from the BCSTH office in Vancouver, and I am Amy FitzGerald, the legal coordinator here, and I am with my colleague, Rashid Ahmed, who is going to be supporting me today in terms of making sure that the webinar works for all of you guys today. So we're going to be recording a portion of this webinar, and then we're going to allow for an opportunity at the end for questions and discussion that will not be recorded. And so we have a few housekeeping matters we're going to go over right now, just so that everybody understands the process for our webinar today. So we're scheduled to go from noon until 1:30. Currently, all of you folks are muted and on a listen-only setting for the recorded portion, and that will go till about 1 o'clock, and then we will end the recording and we will open up the discussion for questions. And we're asking folks to use the chat function box, which is on the left-hand side of your screen, and to write questions down there or type questions down there. And Rashid is going to be monitoring the chat function, and we'll collect the questions for discussion at the end so that we'll have an opportunity to discuss them all there. If folks are having any kind of technical difficulties, we're just asking folks to contact us here at BCSTH and ask for our colleague Paka, and the phone number there is 1-800-661-1040, extension 231, or you could send Paka an email, and her email address is Paka, P-A-K-K-A, @bcsth.ca. Her contact information was also sent out in the reminder email that went out yesterday and today. So just because Rashid and I are going to have our hands full running the webinar, so we just thought that Paka could assist you if you've got any kind of connection or technical difficulties. The other housekeeping matter I just want to remind you of is at the end of the webinar, you will be sent an evaluation you're going to be sent two evaluations. One is a specific one to the legal toolkit, and the second one is a general one from ReadyTalk. So if you could just make sure that you take a little bit of time out of your busy schedules to fill out the webinar evaluation related to the toolkit, that would be really important for us to have here so that we can, going forward, revise and adapt the toolkit to make it as useful and as relevant to your practice. So that would be great. And the other piece we wanted to let you know about is the recording of today's webinar will be posted on the BCSTH YouTube channel in April. So if there are colleagues who are unable to join you today, they'll be able to listen to it on that day. Do you have I'm just asking Rashid if he has any of your housekeeping matters. Nope, I think we're good to go. So hopefully in front of you is the initial slide, the blue slide, which is titled BCSTH Legal Toolkit, and we're going to be using the PowerPoint as we go forward. And then we also have a case scenario that I'm going to be using to help you walk through the toolkit and to show you how to use the toolkit in your everyday practice. So that case scenario was sent as a downloadable file, so hopefully you folks have been able to download it. I'll also be reading the slide that has the case scenario in it, and I'll be using it as we go forward throughout the webinar. So with respect to this project, this is the Legal Toolkit project, and I was hired to work on this project in July of 2015, so I'll give you a little bit of a sense of who I am. I've been a lawyer for over 20 years. I primarily practiced in the United States. I'm currently working with the Transition House Society as a legal coordinator, as I stated earlier, and my focus is to develop legal education and training materials for frontline workers. Previously, in British Columbia, I have been a policy analyst and consulted on projects related to risk assessment in violence against women cases, mediation in family court matters, and safe transportation needs on the Highway of Tears. In the United States, I was an Assistant Attorney General in the Criminal Division of the Vermont Attorney General's Office for about 15 plus years. There I worked on unsolved homicides, and I was the domestic violence prosecutor. I worked on a number of policy and legislative and training issues related to domestic and sexual violence. While there, I founded the Vermont Domestic Violence Fatality Review Commission and was the chair of that throughout my tenure at the Attorney General's office. I also served on Vermont's Child Fatality Review team. Prior to my time in Vermont, I was also a public defender in New York City, and I spent some time working as a legal aid staff attorney in Vermont as well. So my whole background is a public interest background. I have worked in the civil context as well as the criminal context, so I've seen the repercussions of domestic and sexual violence in lots of different forums. And now I'm a relative newcomer to British Columbia and very happy to be here. So I had the good fortune of being hired in July of 2015 to work on the Legal Toolkit project. This was a project that was funded by a civil forfeiture grant that was given to the Transition House Society, and it is winding down. It is the civil forfeiture grants that are going to be finishing up at the end of March of 2016. The timeline that we've set for us is we have a toolkit draft that is completed and has been given to my colleague here, Hannah Lee, to make it look lovely, and that will be distributed to all of you as hard copies in the beginning of April, and it also will be downloadable on the BCSTH website. We're doing 2 webinars in March, this one focusing on the Transition House Society issues, and then we did a webinar last Thursday, the 17th, and that was focused on issues related to the CWWA programs, the Children Who Witness Abuse programs. So in terms of the background for this grant was specifically written to address issues that had been raised by the BCSTH member programs in the past with respect to their need for legal information and access to resources when they were working with their clients. So we used the issues that had been collected here at the BCSTH office, and then we also conducted a BCSTH member program survey. And so some of you probably participated in this survey. It was distributed in August of 2015, and we looked at the results in September of 2015. So the toolkit was really guided by feedback that we were receiving from the frontline workers, and it was very helpful for us to have that information. With respect to the survey, we received over 80 responses, and all the regions and the member programs were represented. 46% of the returns that we received were from the transition houses, and 36% were from the CWWA programs, and the balance were from the second and third stage and safe home programs. The highest response rate for frontline that we received was for frontline workers, which was 62%, with the balance from management of 38%. So we had a significant number of folks who responded to the survey, and that really made our jobs easier here in terms of identifying relevant and useful tools for you. It also confirmed a strong interest in the need for this toolkit. So based on that consultation with the BCSTH member programs, we identified some of the priority or key issues, and the toolkit that you'll be receiving shortly, it really speaks to those issues. And specifically, they are records management practice, confidentiality and privacy, how to respond to subpoenas, how to assist clients when they're having to deal with courts, how to get them access to legal representation, informed consent and capacity issues for children, and protection orders in British Columbia. So the plan, as I indicated to you earlier, is to roll out the legal toolkit shortly. So today you're just going to be getting sort of a little bit of a teaser of what's in the toolkit and how you can use it. And the way we're thinking of what will happen with this toolkit is that it is designed to be sort of a comprehensive overview of some of these topics, but the individual information sheets are also designed to be used and pulled out separately and perhaps used for training, perhaps a lunch time, a bag lunch session on informed consent or on issues related to parental consent, for example. So when the hard copies are sent out to you at the member programs, it'll come in, the toolkit will come in a 3-ring binder with a table of contents. And again, this information will be sector specific and hopefully responsive to your needs. And the way we envision it here is a living document in the sense that we want it to be revised and added to and amended to meet your needs. And so that should be coming out to you in early April, and at the same time it will also be downloadable on the BCSTH website. So you can pull sections of it and use it in an ongoing basis in your practice. So this slide gives you a sense of what's in the table of contents and what we've tried to address in the toolkit. So specifically, we have a section that relates to an overview of courts and legal resources, and in that it talks about British Columbia courts, accessible legal resources here in BC, and Legal Services Society, and how to appeal the denial of service from legal services. We have a section that's related to court-related matters and how to support clients, and that includes topics such as affidavit writing, preparing a client to be a witness in court, protection orders, and how to respond to subpoenas and records requests. We have a section related to record keeping, and specifically in that section we talk about what is in a client record or should be kept in a client's file, how to take notes, records management practices, and also records retention and destruction. And then we have some specific information sheets related to certain populations that you are working with. Specifically we have a section related to the Children Who Witness Abuse programming, and the topics there that rose to the top in terms of priorities were parental consent and CWWA counseling, and also informed consent for minors and CWWA counseling. We also have information sheets that are focused on working with immigrant and refugee women, women and children with disabilities, and Aboriginal women and children. So that's just a brief sense of what's coming your way shortly. So as I indicated today, what we're going to be doing is as I walk you through the toolkit, I'm trying to give you a sense of how you can use it in your everyday practice. I drafted this case scenario to help us give us a little bit of a guidance to walk through that toolkit. So I'm going to be reading portions of it to you now, and then as we go through the PowerPoint this afternoon, I'll continue reading the 4 questions. So this is entitled Transition House Legal Toolkit Case Scenario, March 24th, 2016 webinar. The transition house has a new employee who is working with a woman who has come to the house with an 11-year-old child. The mother and her child both have experienced violence by the father. The employee has a supportive relationship with the mother that has included assistance with the mother's pending legal case, such as writing a letter to the court regarding the child's safety and residency. So question 1 that we're going to be talking about first is the new employee is aware of the pending family court case and is concerned with what is considered a record and how much information should be included in the woman's file and in the employee's notes. I'm just going to read through all the questions now, just so folks have a sense of the direction that this case scenario goes in. Question 2 that we'll be addressing is the mother has been representing herself in court and was granted a family law protection order restricting the father's access to her child, but the father is represented by a lawyer now, and he has just been granted joint custody and guardianship in the family court case. Because of the recent court decisions, the woman applied for a legal services lawyer. The mother brings her legal aid representation services refused form to the employee and asks for help. She is also concerned because the protection order terms conflict with the custody and guardianship order. Question 3 relates to the woman is thinking about moving to live in another province with family members. She's asked for copies of her file and wants to know how long the transition house will keep her records and her child's records. And when the employee goes through the file, she finds the woman's journal in the transition house file that is in place there for safekeeping, and the employee is concerned with that practice. And finally, the father's lawyer serves a family court subpoena on the transition house for the mother's records and the child's records. So we're going to be walking through all of these different steps and trying to show you how the toolkit will assist you in analyzing these kinds of situations. So with respect to question number 1, this relates to the employee is aware of the pending family court case and is concerned with what is considered a record and how much information should be included in the client's file and in the employee's own notes. So in the toolkit, we have an information sheet that is entitled Records Retention and Destruction Information Sheet. So this is a section which gives you an overview of how to retain files, what should be retained, and when they should be destroyed and why. So specifically, this section discusses how transition house employees need to document in their records information that is necessary to provide services while being mindful of the woman's safety and what records could undermine that safety and also support that safety. And within this information sheet, we describe what a record is. And again, this is within the context of sort of orienting a new employee as discussed in this case scenario. So record is defined broadly to include all recorded information, regardless of physical format. So it includes books, documents, maps, drawings, photographs, videos, audio tapes, letters, papers, and any item on which information is stored or recorded, whether it be graphic or electronic. So emails are records and need to be managed in the same way as paper records. And when we think about program records, specifically, program records can consist of operational, administrative, and program participant records. And all those records contain personal information. Personal information is information that can identify an individual directly, such as their name, address, phone number, and any identifying numbers or personal identifiers. It also includes information that could link the information to the identified person, such as physical descriptions, educational background. It does not include business contact information as the statutes are written, but it is a broad definition. So operational records of the Transition House Society would include program participant records. And so the information provided here is just to orient your new employee and yourselves as to what is a record and how do statutes and how do address these different types of records in terms of record keeping and record management. The toolkit also has an information sheet that is specific to note-taking and clients' records. So again, in this case scenario where you have a new employee, this is something that you can use hopefully to identify how to take notes and also to identify what records should be kept in the files and why. So again, frontline workers we know are faced daily with the need to document interactions with their clients in a fact-based way, with the knowledge that anything that's recorded and collected may be subpoenaed or requested in a criminal, civil, or family court case. And so we have some criteria here to assist frontline workers to identify what records they need to maintain to provide services to their client while being mindful of the overall safety of the women and children that they're working with. Within this information sheet, we specifically provide some questions, some guidance that you could, with this new employee, talk about or perhaps have a lunch meeting discussion with all of the staff about. And specifically the questions are as follows. What is the purpose of collecting or recording the information? Will the recorded information improve the services for the program participant? And is the information necessary to determine and deliver the appropriate services? Is the recorded information your subjective perspective of the woman or the child situation, or is it fact-based? And the emphasis should be that it is fact-based. What will you do with this information once it is collected? Could the collection of the information be harmful to the woman and her children in terms of gaining access to services or to any future legal cases? And finally, could the information be harmful if subpoenaed or disclosed to a third party? And within this discussion, this information sheet encourages you to consider, is it best practice to collect minimal information? And it asks programs to consider that the more client data that is collected, the greater the potential confidentiality risk to victims, and the more steps your agency will need to take to protect that larger amount of data increases. So when you're creating policies that address how long to keep agency records and what should be in those records, it's important to examine what the data is being collected for and the purpose. So for instance, if your primary goal of your services is to support survivor safety and confidentiality, then your program should make sure that in your collection and retention policies that is reflected. So in the information sheet, we specifically list information to consider in terms of what can be in a client record and what should be in a client record. So we list things such as intake forms, informed consent forms, release of information forms, service plans, third-party reports, safety plans, closing reports. And again, it's to give you guidance as a program and to give employees guidance as a program to think, should this be in this client's file and why is it there? We also provide guidance specifically related to working case notes. And we talk about note-taking, and we provide the following guidance. And this would again be something that you could use with this new employee who's asking you specifically, what should I be putting in my case notes? So case notes should be kept up to date and recorded as soon as possible after every session and initialed and dated by the author. The notes should reflect the session that just happened, not historical or legal facts. They should record information that is needed to provide the service to the program participant, and it should record what is needed for colleagues to also support that program participant. Working case notes should be brief and note major topics and themes and keep details to a minimum. You should avoid documenting verbatim accounts, and you should be objective and not include subjective comments. The working case notes should be fact-based and avoid speculation, and should avoid information about people other than the client except when necessary. The working case notes should be in a common format and be legible, and should be kept in ink with corrections made by crossing out the deleted material so that it can still be read and you can still document the history of those corrections. And in the information sheet, note-taking and client records information sheet, we have a number of sample forms that you as a program can review to determine whether they would meet your needs, and you can amend them and revise them going forward. So again, these would all be forms that you could go over with this new employee, and specifically they address intake information, informed consent information. We provide you with a sample service or case plan, and also a closing report and authorization to release information templates. So again, these are templates that you can look at, revise, amend, and hopefully it'll help you going forward to have a clear records management process, as well as a note-taking and client record process. So hopefully some of those information sheets will assist you if you are orienting a new employee, as is discussed in this case scenario, and also give you some food for thought going forward as a program in terms of how you keep records and why you keep records. And the other thing I'm just going to let you know about now is that there's also a section in the toolkit that relates to online records and online databases, because I know that there are some programs out there that are concerned and considering those, and so we do have a section that relates to that, because that would, that expands the definition of a record, that expands the definition of your obligations in terms of confidentiality. So it's just another, another area that hopefully this toolkit will help you consider and think about. So now we're going to move on to the second question in the case scenario, which specifically states, the mother has been representing herself in court and was granted a family law protection order restricting the father's access to her child, but the father is represented by a lawyer now, and he has just been granted joint custody and guardianship in the family court case. Because of the recent court actions, the woman applies for a legal services lawyer, and the woman brings her legal aid representation services refused form to the transition house employee and asks for help. She's very concerned because the protection order terms, which restrict access to the child, conflict with the custody and guardianship order that has just been issued. So with respect to this topic, the toolkit provides information regarding accessible legal resources in British Columbia. And in this case scenario, obviously, the good news is that she was able to go to court on her own and she was able to get a protection order, but oftentimes that doesn't happen, so that might have been a rosy scenario there. What we're finding right now in British Columbia is self-representation in court matters is increasing exponentially across Canada as well as British Columbia. The 2015 figures from the Provincial Ministries of Justice show that self-representing litigants in trial-level family court cases are consistently at or above 40% of the cases. And in some provinces, that percentage is far higher. So we are in a situation where a lot of women are having to represent themselves in court, and that raises significant hurdles and challenges for all of us. The BC Court of Appeal reported in 2013 that they saw at least one self-represented litigant in 38% of family court appeals, and these are appeals, not trial-level actions. And 24% of civil appeals, there was one self-representing litigant, and even in 11% of criminal appeals, there were self-representing litigants. So access to legal information and resources at both the trial and appellate level is a critical need. And so the toolkit provides a list of accessible options for people who find themselves representing themselves in court. And the information sheet is entitled Accessible BC Legal Resources, and it provides links to resources related to self-representation in family law matters, self-representation in general legal matters, and also just general legal resources with the links so that you can take this information sheet and then it will hopefully link you to another resource that you can use to assist your clients when you're trying to determine what are the legal resources out there for folks that you're working with. There's some good news in this area now that I've provided you with all the bad news, but in the lower mainland of BC, West Coast Leaf is going to be starting a women's legal clinic, and they're going to be opening their doors on May 1st, 2016. And the executive director of that clinic is a woman by the name of Kim Hawkins, and she practiced up in the Yukon for 10 years. And she was on the board of the Yukon transition houses up there. So she has reached out to the BC Society of Transition Houses here, and we have met with her, and we're trying to come up with some intake forms for women who are staying at transition house programs to expedite their referrals to the Women's Legal Clinic. Now, again, this would only apply to folks in the lower mainland. I think the goal of the Women's Legal Clinic is to try and expand that to other sections of BC. So some good news there, albeit small, but we'll be working with the Women's Legal Clinic going forward and collaborating with them to try and provide meaningful legal representation to women who are trying to represent themselves. So in this case scenario, she's had some luck on her own, and she's been able to get the protection order, but now she's faced with problems related to conflicts with the protection order, and she's thinking that perhaps she should have an attorney. So in the case scenario as presented, she's applied for a legal services lawyer, and she's been denied services. So we have a information sheet in the toolkit that is specific to Legal Services Society and how to appeal a service of denial for legal representation. So as many of you know, Legal Services Society is the Crown Corporation that provides free legal aid in British Columbia. Legal Services Society, or LSS, has 2 regional centers, one in Vancouver and one in Terrace. And they provide services in a total of 35 communities in BC. They provide legal representation as well as legal advice to qualified persons. And they also provide public education and information, which can be found at their offices and also on their website. Legal aid lawyers are available for family, criminal, mental health, child protection matters, immigration matters, and some appeal cases. And BCSTH program participants may be eligible for legal aid services, and legal services right now is really encouraging that folks apply at an early stage for legal representation or legal advice, with the idea that it may prevent identified legal problems from escalating and could help clarify a woman's legal options going forward. So when you apply for a legal aid lawyer, as some of you probably know, to either get legal representation or legal advice, there is a call center, an LSS call center, and it's a toll-free number. Services are provided in English, and also interpreters are available. The call center welcome message is available in 6 languages: Cantonese, English, French, Mandarin, Punjabi, and Spanish. You can also go to a legal aid office or to a courthouse intake office. And the website, the Legal Services website, provides a list of locations and their hours. With respect to the application and the eligibility, for legal representation, the LSS intake person will be the person who takes the application, and then they make a determination as to whether the legal problem is covered by the legal aid rules, whether the person meets the LSS financial guidelines, and whether the applicant has no other way of getting help. So in our case scenario, the woman went, she obviously applied through an intake person, and they went through the criteria, the LSS criteria, and in this case, for whatever reason, decided that she was not eligible for services. As part of that intake process, they will ask for information about the legal problem. They will also ask for information with respect to the monthly income of the applicant. And they have certain items that are excluded from the income, such as child tax benefit or BC family bonus, and they list them all. There are also allowable deductions, such as daycare expenses and medical service plan payments. So it's a pretty elaborate criteria that they go through. And then the legal intake assistant determines the financial eligibility. And in the information sheet, we have all this information, so you can work with your client to determine whether they are eligible or not and what criteria they're going to need to provide to them for that intake process. Just for background purposes, as an example, the January 2016 guideline provided that the net monthly income for, in this case, we've got 2 folks in the household because you've got a mother and child. So the net monthly income after the deductions is $2,100, just to give you a sense of what the financial guidelines currently are. So in this situation, the legal representation application was denied, and the important thing for folks to know who are working with clients is that you have a right to apply for a review of that denial, because there are a fair amount of people in the community who do not know this. At least that's what became clear when we did our survey to member programs. So they will be provided a legal aid representation services refused form, as was provided to the woman in the case scenario. And the form states the steps that must be taken for review. It must be done within 30 days from the date of the decision. So in this case, our new employee would sit down with the refusal form and could pull out this information sheet and say, you've got a right to apply for review, and this is what we need to do to get you in the review process. The request for review must be in writing. It must set out the reasons for disagreeing with the decision, and it must include copies of any supporting documents. The request for review is mailed or faxed to a provincial supervisor at the legal aid application office in Vancouver, BC. The review process can take up to 3 weeks, and the notice comes in the mail. So that might cause problems with respect to folks who, for instance, let's say they're only at the transition house for a total of 30 days, and where their mail is going. So that's something that you would have to sort out, whether the information could be sent to a family member or a friend of the client you're working with, or perhaps she has a work address, or for instance, perhaps the transition house has a P.O. box that residents get mail at. I don't know, but that would be something that you could sort through with the client. If it comes back with a negative decision on that appeal, the Legal Services Society still can provide advice, legal advice, to your client and to the woman here. And so she could reapply. Sadly, the Family Legal Advice Services have a financial eligibility test that is similar to the eligibility guidelines that we just went over. But if she doesn't meet those the financial eligibility guidelines, she still may be able to get general help and advice from family duty counsel or up to 1 hour of advice from a lawyer. And so there are, I guess the important thing to think about is that there are options, and that it's important to inform your program participants of the fact that there are options out there, and that to keep asking for help. I think that would be the important thing. And in this situation, the final piece that she's concerned with respect to her legal situation has to do with the conflict between the protection order that was issued in this case that restricted access to her child, and now the recent decision in the family court case allowing for guardianship and custody, joint custody and guardianship. So in the legal toolkit, we have specifically an information sheet that relates to protection orders. And that information sheet talks about the differences between the different types of protection orders, the BC family law protection orders that was provided for her in this case, and also peace bonds. And we talk about the pros and cons between applying for these different orders so that you can sit down with your clients and make a determination as to where is the best forum for them and what is the most protective measure for them. The important thing to know about, and it's discussed in the protection order information sheet, is it talks about once an order is issued, whether it's a family law protection order or a peace bond, they are both sent to the BC Protection Order Registry. And though that is a protection order registry database, the Family Law Act orders are sent by the civil courts, and the peace bonds are sent by the police or the Crown Counsel. This is a confidential computer base for BC that contains all the civil and criminal protection orders issued in BC and maintains them indefinitely. The registry is available 24/7, and a person can report a violation of the order anytime, day or night, and law enforcement should act to enforce that order. So the system provides an instantaneous response to queries, and on average, just to give you a sense, in 2015, 51 search requests were completed by the Protection Order Registry staff every day. So it's just important to know you've got a client here who got the order on her own, but she may not be aware of the existence of the Protection Order Registry. She may also not be aware of the fact that she can check whether the orders are registered and the details of the order by contacting Victim Link BC, which again, as you know, is a toll-free, confidential, multilingual service that's available across BC 24 hours a day, 7 days a week. And then finally, you also should reiterate with her that she needs to register or should register for victim notification. Registering is done through the Victim Safety Unit at the Victim Services and Crime Prevention Division of the Ministry of Justice, and it provides the person with information as to the status of the order and the correctional status and release of the perpetrator if there are criminal charges or criminal matters pending, and any issued conditions. So the information sheet provides you the context for all these entities to make sure that this protection order is as fulsome as it possibly can be. With respect to this case, the information sheet also talks about what happens when you have conflicting orders, conflicting court orders. So specifically, the family law, the BC Family Law Act in Section 189 provides guidance on conflicting orders and clarifies that safety-related protection orders trump other civil or criminal non-protection orders. So here, the family law protection order that was issued to restrict access to the child would be considered a safety-related protection order. So the family law protection order in this case would trump the joint custody and guardianship order in family court case. So, for example, a family law protection order, or it could also be a peace bond, as long as it has a protective and addresses safety needs, protective measures that address safety needs, it would overrule the court order in a guardianship or parenting order. So what would happen in this scenario is that the parenting and joint custody order would be suspended until to honor the protection order. And so what could happen in this case is that the woman should probably go back to court to clarify that with the court for clarification. And this might be something that if she were successful in getting an attorney, she would definitely want to advise him of that. If she wasn't successful in getting legal representation, if she just was successful in getting legal advice, this would be a topic that she should raise with the attorney, because there are protective measures in the law that will protect her and her child in terms of access to the father, but it needs to be raised in a clear manner. And sometimes having that legal consult and legal advice could help her. You can advise her of it and work with her to work through this, but having a lawyer may also assist her in this circumstance. So we're going to move on to question 3 of the case scenario, which states the woman is thinking about moving to live in another province with family, and she has asked for copies of her file and wants to know how long the transition house will keep her records and her child's records. The new employee finds the woman's journal in the woman's transition house file that was placed there for safekeeping. So in this situation, specifically, the toolkit in the protection order information sheet talks about the enforcement of protection orders when protected persons move out of province. And so the important piece that is discussed in the protection order information sheet, when you look through it, it talks about all these other previous steps that we talked about just a bit ago, about how to make sure that the orders are in the BC Protection Order Registry, that the protected person is registered for victim notification. So sort of all those protective measures are in place. And then if a protected person moves out of the province, there may be additional steps required to assure that that protection is respected in other places in Canada. The order may have to be registered with courts or the police in a new location, or a new order may have to be requested in the new province. So, and in a similar fashion, if a person moves to BC with a civil protection order from another province, the protected person must go to a BC court and ask for an order authorizing the police to recognize the order and to enforce it and register it. So there are bumps in the road in terms of making sure that these protection orders are respected in other places. They're not insurmountable bumps, but they're bumps that we all need to be aware of. There is a Canada-wide computer system entitled the Canadian Police Information Centre, or CPIC, which is available to confirm a protection order in its terms. But the way CPIC is set up, it will not enter an order received directly from a protected person. The order has to come from the courts or the police to be registered. So there needs to be some sort of connection with another entity, whether it be a court or police in the new jurisdiction. So in this situation, with the woman who is contemplating moving to another province, what the information sheet talks about is trying to coordinate with support services in another province. And we have some great resources out there that are listed in the toolkit, specifically the Canadian Network of Women's Shelters and Transition Houses, which was incorporated and became a charitable organization in 2012. And BCSTH is on the board of the Canadian network, and so they provide a national forum for shelters across Canada to share ideas and resources. So they're going to be a resource for you going forward in terms of connecting with folks across Canada. And they specifically operate sheltersafe.ca, which is an online resource which help women and children seeking safety to find services across Canada. And they have a clickable map which serves as a fast resource to connect women with the nearest shelter that can offer safety, hope, and support. And so these are two resources that you could bring to the attention of your client here, and that you could work with her to coordinate the move to another province to make sure that she has a safe place to land, and that her protection order can be respected and honored in that new province. With respect to her request to see copies of her file and to know how long the transition house will be maintaining her records, the toolkit again has information sheets related to records management. Some of them we discussed earlier. And with respect to the records management information sheet, the way it's broken down is it talks about why and how the BCSTH program should keep the records, and it goes through program procedures as to how the records should be kept and how they should allow program participant access to the files. And specifically with respect to the program participant access, requests by program participants to review their files must be honored except where precluded by law, for example, in a child protection matter. And it allows them to review their file, to take notes about the contents of the file, and to get copies of the file. It also talks about, it gives you the criteria for a program participant requesting corrections or removal of data or information that they feel is inadequate or irrelevant, and it provides you the process for doing that, and how to keep records of those requests, and how to keep records of your response to those requests. And it also talks about the safekeeping of program participants' personal items. So as indicated in this case scenario, the employee has found a journal of the woman that was placed in the file for safekeeping. Now, obviously, that's something that should be returned to the woman as part of this file review, but the danger of placing documents or materials that are sort of personal identifying information like this for safekeeping is that they are discoverable if there are requests for client records or subpoenas for client records. So, and we talk about that within the records management information sheet, and then we also talk about that within the note-taking information sheet, specifically when a program participant asks the agency to hold personal papers, such as a journal like this, or birth certificates, or passports, or immigration documents, or school enrollment cards for safekeeping, we just caution you to think about that if these items are held in the program's records, that they could be subject to disclosure under subpoena or record request. And since they would be potentially subject to discovery, another option for the program to consider is whether there's a local trusted family member or friend that could safeguard these items, or perhaps place these items in a safe deposit box if you're concerned with the fact that these items might be discoverable in a case. And in this situation, as noted here, in question 4, the scenario is drafted so that the father's lawyer serves a family court subpoena on the transition house for the mother's records and the child's records. So again, something to think about in terms of your internal practice as to how you want to proceed with this. The other issue that was raised in question 3 that would be addressed in the toolkit relates to maintaining separate files for different programs and participants. Again, if you're running multiple programs, it is recommended that you have separate records kept for the different programs. So you would have records kept for the child in this case, and you would have records kept for the woman in this case, and to try and keep that sort of records management differences clear, and we have recommended practices as to how to share information back and forth between those two streams of files. The other question that the woman had here with respect to records retention of her files. So there is an information sheet in the toolkit entitled Records Retention and Destruction Information Sheet. And so this is something that, as recommended in the toolkit, it talks about the reason why you keep records, and also how you have certain obligations to maintain those records, and how that oftentimes is based on your, sometimes based on your legislative and contractual obligations that govern your program and the program's funding sources. It's a complicated topic, as you well know, and so we've tried to break it down in a way that's manageable for you to review as a program. The important part of the discussion is to have an informed consent process with your program participants so that they understand the retention rules going forward. So with respect to the statutes that are discussed in the information sheet as to retention and destruction of records, there are statutes that govern some of this information that discuss at a minimum, the information must be kept at a minimum for 1 year, but the same statutes do not identify the maximum time for record keeping. So the legislation recommends that your organization review your grant, your financial, your regulatory, your legal obligations under all of those different criteria. And basically, as a general rule, 7 years has been identified as the time frame that meets most of these requirements. And there are exceptions to those requirements, and they're discussed in the information sheet. So adult client records should be kept for a minimum of 7 years, and the records of a child client would be kept 7 years after they reach the age of 19. So in this case scenario, the child is 11, I believe. So you would have a long period of time within which that you'd be under an obligation to maintain those records. And so again, we also in the records retention and destruction information sheet, we discussed the various laws that relate to this section. So specifically, FIPA and PIPA, the Personal Information Protection Act, all the IPAs that everybody shudders to think about, they're discussed in here in a way that's hopefully going to be useful for you going forward to determine how long you're going to be maintaining these records and to make it consistent with the laws that are out there. At the end of the 7-year period, we do give you advice as to what critical information from the record should be transferred into a file summary form, or if you're using an online database, to an online database. And we have a sample file summary form which you could take and again revise for your own purposes in terms of maintaining records. And the caution again with respect to the safekeeping piece with respect to this woman's journal we talked about earlier, but it also ends up in a situation where when you're reviewing the files, and if you find something like that in there, it raises an issue as to whether you would have to retain that or whether you could destroy that, because it's not something that you created, it's something that a client created. So that's another thorny issue that you can discuss as a program as to whether you want to be maintaining these sort of personal items of your clients, and we can assist you with trying to come up with a policy that works for you. The final question relates to the father's lawyer serving a family court subpoena on the transition house for the mother's records and the child's records. So, and I'm conscious of the time because we're coming up to the time when I want to open the floor for questions. But I just want to make sure that you guys are aware of the fact that in the toolkit, there is an information sheet which is specifically entitled Responding to Subpoenas and Records Requests. And it talks about the fact that the reality of the work that we do is that any information that a frontline worker is witness to or records or collects in their files may be subpoenaed as part of a legal proceeding. Although you're considered a third party to this legal matter, you can still be asked to appear as a witness or to produce records. And these requests are part of a discovery process that is allowed in pending court matters. The important thing for you to know as a frontline worker is that you have responses to these types of requests. And nobody likes to be nobody really likes to go to court, even lawyers. Nobody likes to be subpoenaed. Nobody likes any of this. But the bottom line is for you as a program and for you as frontline workers to realize is that there are resources and options for you in steps that you can take to maintain the confidentiality of your program and the confidentiality of the women that you work with. So the court process and the requests for information vary according to the nature of the request and the underlying court case. And basically the reason why these subpoenas or requests are issued is because there's a party to the court case that believes you have material evidence in the pending court matter. So in this case, the father perceives that there's something at the transition house that is material or relevant to the pending family court case. The program should proceed in terms of responding to subpoenas on a case-by-case basis, and we provide to you in the toolkit specific steps that you should take. You should be aware of the fact that oftentimes subpoenas are served by personal service. So a server, a professional process server may come to the transition house and serve it. You can accept service. The important part when you accept that service is to not reveal any confidential information in response to that service. And you should review the paperwork, advise your supervisor, and you should advise your client, because your client or the program participant has a privacy interest in the records that is separate from the privacy interests that the program has. So we have it in the toolkit information sheet. There's a sample letter attached, which is basically a letter that you could provide to the person who has asked for these records, which is just a receipt, basically saying that we have received this subpoena or this record request in this matter. We have read the paperwork. We are discussing the paperwork with our legal counsel, and we will be in contact with you before the court date, just to make it very clear that they know you've received it and you're considering your options. And in these situations, really, this is the time when, given the overlapping and complex legal issues that frontline workers address and the multifaceted issues here, it would be important for your program to develop an ongoing relationship with a lawyer who, in circumstances like this, could represent you. With respect to getting representation for your client, there are also options for legal representation that may be available through the Legal Services Society and volunteer lawyers. So again, if this were to come to pass with your program, there are options out there for getting legal counsel. And once legal counsel is involved, the lawyers will communicate with the other lawyers as to compliance with the subpoena. And with respect to compliance with the subpoena, in this case, it's a civil case. That's the underlying matter. And but the motion or the request for records can be challenged if the evidence is not relevant and is considered protected. So your lawyer can file a motion to court to try to set aside the subpoena. And specifically, court cases allow for an argument to set aside these kinds of records requests And the judge will consider if the communication was given in confidence, so it's a confidential communication, which typically, if working with transition house folks, this communication was given in confidence. If the confidentiality is essential to the relationship and the confidential relationship fosters a public good. So if these 3 items are met under court cases, the judge must consider whether the privacy interest in protecting this confidentiality, whether it outweighs the interest in finding truth and disposing of the civil case correctly. And you should be aware of the fact that there are cases, court cases, where judges have refused to disclose counseling records from a transition house programs on the basis that the records were not relevant and were privileged or protected under these standards. So there is some good case law out there that you can raise in the context of trying to set aside or to limit a subpoena or a record request. If the judge does order compliance with the subpoena, you can still ask for limitation in the judge's order, limiting conditions such as only allowing relevant portions of the records to be released, only allowing a limited number of copies of the documents. And this is all laid out in the subpoena information sheet. So hopefully this will give you and your counsel some guidance on how to comply with and to address any kind of records requests or subpoenas that you may see. So I think we are up to the point where I'm just going to give you a quick overview of the next steps for the toolkit, and then we will stop the recording, and then we will take questions. So as I stated earlier, the final draft of the toolkit is in Hannah Lee's capable hands to make it a beautiful document. And that should be coming to you the beginning of April in both hard copy and also will be downloadable on the BCSTH website. And then what we would really like to hear from you is what sort of future topics you would like to have included in the toolkit, and also what sort of future topics you would like to have us address in webinars. And so consider contacting us with respect to what topics you'd like to see going forward. And you can do it through, as I indicated, through the Ready Talk webinar evaluation form that will come to you. You could also do it through the listserv or email or phone calls. And my contact information is in the next slide that we're going to get to. Topics that some folks have raised already is addressing mediation in family court matters, which is not addressed in this toolkit. So we'd really like to know what you would need to make this toolkit as useful a resource and as relevant a resource for you as possible going forward. And because it is going to be in a binder, we can add and revise and amend it very easily, and also it will be downloadable through the website. So it will be a living, breathing document that hopefully will stay relevant for you. So I'm going to skip to my contact information. So again, please feel free to contact me directly with any questions or concerns. And I do hope you also fill out the webinar evaluation form, because that gives you an opportunity to provide us feedback too on how to make the toolkit more useful for you. So I think at this point, we will stop the recording, and then we'll go to the discussion format. So if folks have questions, we'll try and address them that way. So thanks very much for joining us today.